Hi everyone, Brian Valerio, Vice President in the Proxy Solicitation Group at Alliance Advisors. Today I want to talk about California Governor Newsom signing legislation that's going to require boards of publicly traded companies that are headquartered in California to have at least one racially, ethnically, or otherwise diverse candidate on the board by 2021. This is the first requirement we've seen like this in the United States, and it is similar to legislation California previously enacted that required female directors to serve on all publicly traded companies that are headquartered in California. So the law is going to go into effect for 2021, and it is going to require publicly traded companies that are headquartered in California to have at least one ethnically diverse director at first. Then for 2022, those numbers are going to increase, and the amount that they increase is going to depend on the overall size of the board. So starting in 2022, for boards that have more than 9 members, there is going to be a requirement that they have 3 ethnically, racially, or otherwise diverse directors on that board. And for boards that have between 4 and 9 members, the number is going to jump to 2. So what we're seeing here is we're seeing a continuation of the consistent push for racial and ethnic diversity that has been heightened since the social justice movements that were ignited with the killing of George Floyd. And what does it mean under this California law to be ethnically, racially, or otherwise diverse? Well, there are a couple of different categories that people can fall into in order to satisfy the statute's requirements. Some of those include Black, Hispanic, Asian, or you could also be gay, bisexual, or transgender. Those are just some of the different self-identifications that would satisfy the law's requirements. And this law is likely to be challenged in the courts the same way that the law requiring females to serve on boards in California was. And the challenge is going to likely focus around the Equal Protection Clause of the United States. Essentially, the argument is that it violates that clause. The argument on the other side is that there's a compelling need to enhance diversity on corporate boards, and this helps to address some of the racial injustice and inequality that we have seen in our society in the United States. Now, many believe that it is imperative for corporate boards to reflect the diversity of the states in which they reside. And that is certainly what is being considered by the California legislature by enacting this law. And the belief goes that there's benefits to corporations with ethnically diverse boards, and that those boards, data has shown, actually tend to perform better than less diverse boards. And one of the reasons why people believe that diverse boards perform better is because there's a belief that diverse board members can provide insight into communities from which they came from, that otherwise wouldn't be heard by those board members. There's also a belief that diverse board members can better consider issues and the needs of all the key stakeholders, and from their shareholders to their employees. So having a more diverse board captures more of that perspective for the different stakeholders. So that's also viewed as being an added benefit to having a diverse board. Finally, there's a belief that diverse board members can raise issues that relate to class and preferences of the broader community that the corporation serves. So that's another potential added benefit to having diverse boards. This is a major change. This law was just enacted and signed into law by Governor Newsom. As I mentioned, there's probably going to be some litigation surrounding this. So it's going to be very interesting to see how this develops over the next year or so as this mandate gets put into place. So please feel free to reach out if you have any questions about this, board diversity, or board composition in general.